So following the really unusual turn of events on Thursday with Tommy Robertson in court, where he claimed that they disconnected his phone while he was talking to his lawyers, there is now a judgment, which I'll go through a little bit of in this video. I won't go into great depth because it's a long judgment and the details are relatively straightforward. But there is also another video on this by my learned friend Alan Robertshaw from Art of Law, as it rhymes. I'll link that in the description below. He goes into a little bit more detail on different things and also points you towards another video he's done about judicial review. So let's talk a little bit what was this hearing about in the first place. What is a judicial review? And if you could please do me the favor of subscribing to the channel down below. About half of you don't do that. I am independent from the mainstream media. I will go through these things. I will explain it in probably more detail than they will do so to help you to understand it. That is my duty to you, and in return, I just ask that you subscribe. So thank you very much for doing that. Well, when you want a decision to be reviewed, so it's going to be a public law decision on a matter of public law, you can get the court to review that decision. And if the court believes that it's the wrong decision, or it's considered something that it shouldn't have considered, or it didn't consider something that it should have considered, it can quash the decision, remit it back to the decision maker, and so on. So in this case, the decision upon multiple grounds was his being kept in isolation or segregation. And so in essence, his claim was that he shouldn't be kept in isolation, and there were various grounds upon which, like human rights grounds and things like that, which I'll go through in this video. So there's two parts to a judicial review. First, you need permission. It's not, you don't have the right to have these decisions reviewed. You need permission. That's the permission stage. It's a very long form, so that is often a very complex area, and very often, in fact, if you're successful on the permission stage, it usually means that there is something that you'll be successful on later on. And so there's two parts to this, so the permission stage and then the full judicial review. Thursday was not the full judicial review, it was just the permission stage. And so what was interesting, as picked up by Al, was that it was not what they call a rolled up hearing, meaning it wasn't the permission stage then to be immediately followed after by the full permission hearing. It was just the permission stage, which can be, not always, but it can be a clue that actually they don't think that there's a likelihood of granting permission. And so it was just that permission stage. And long story short, permission was refused. And there's various grounds on which, and a lot of people feel that I understand that a lot of people are very emotional about this, and they feel that Tommy Robertson has been mistreated, treated unfairly, treated badly, etc. But there's a systematic analysis by the judge, and a lot of questions have been answered here, and ultimately permission was refused on various grounds. You still may feel that this is not fair to Tommy Robertson. You may feel that he's not in the best conditions, but at the end of the day, it is prison, so it's not going to be obviously as comfortable as somebody might like it to be. Now, just to clear up as well, a lot of people feel that he was put in prison for showing the film. Now, whilst it's technically true that he showed the film and then it resulted in him going to prison, but the reason for going to prison was that showing the film and repeating those allegations was in breach of the injunction, the order not to do so, because of the original libel case. I've talked about that in a lot of other videos, so I won't repeat any of that here. But let's move to the judgment itself and review a couple of the dates here. So when he came back to the UK, he was arrested under a bench warrant and brought to court on the 28th of October. Of course, then he accepted that he was in breach of the injunction, and he was sentenced to 18 months, less than 3 days in custody. And of course, as a matter of right, you serve half of that sentence. And thus, whilst the expiry of that sentence is the 24th of April 2026, under Section 258 of the Criminal Justice Act 2003, he's entitled to automatic release at the halfway point, which will be the 26th of July this year. But he's also facing the other charges for the offence under the Terrorism Act. That's what I've talked about before as well. I think that was to do with the phone and refusing access to the phone and the PIN number and so on, and also for a breach of the stalking order. I don't think I've talked much about that before. But then the judge goes through systematically. This is available online. I'll try to remember to link it, and you can go and read it if you wish. But broadly speaking, you can screenshot it and see much of it here. I've just realised that not all of it is showing on screen. That's just my sharing software is not great. So The judge goes through here how he's being treated in prison and so on. And obviously, being in prison is not going to be a comfortable place to be. But the judge then says, Rule 45 of the prison rules allow a prisoner to be kept in segregation or isolation, away from other prisoners where there's a certain risk involved. The judge then outlines the time frame of being kept in isolation, segregation initially for 72 hours. And that's either usually for the prisoner's own interests, and then there must be a review, after which that must be reviewed every 14 days. It can be authorised for 14 days and then must be reviewed again every 14 days. And any segregation beyond 42 days, and for each subsequent period of 42 days, so then blocks of 42 days, requires permission from the Secretary of State. And so all of that process, as you'll discover, was followed and they've been reviewed. And so his first segregation was reviewed in accordance with Rule 45 on the 4th of November. It was noted that he was spending time in his cell writing emails, using his phone. He had a TV in his cell. He was going to order a stereo. He could go to the gym and had other visits and so on. And then here's quite a pivotal point in my view here, which a lot of the following will turn. So on the 13th of November, a prison official went to speak to him and he was asked whether he wished to be relocated to the main part of the prison. He noted that 35% of the prisoners at Woodhill are Muslim, but said that it was a decision for the governor. He was asked if he would wish to relocate to a vulnerable prisoners unit in another prison. And accordingly here, he denied, saying that he won't live with sex offenders. The governor, Miss Marfleet, spoke to Tommy Robertson in person and he confirmed this view to her. She nonetheless convened a risk assessment meeting with the senior leads from each of the relevant departments from the prison. And then they talked about the risks to him, the risks to other prisoners. A number of options were considered. Relocating to a normal prison was not appropriate given the risk between him and Muslim and non-Muslim prisoners, and on the whole, the risk between them all. He said he didn't wish to be relocated to a vulnerable prisoners wing because he might pose a threat to other prisoners there, given the nature of his activism, etc. Allowing him to associate with a small number of other prisoners would be problematic because those prisoners would have to return to a normal location and then they would be at risk because of their association with him. So you can see the different associations causing the risk of different views and different activist views and so on. This was beginning to be a bit of a problem for the prison. Even if he spent time with a few people and then those people went back to main areas, then they might be at risk because they've been associating with him. So you can see the problem here. So on the 15th and 14-day intervals thereafter, the reviews were held. Then on the 21st of January, he was placed on a waiting list, having reported history of PTSD following the previous segregation, etc. And so it goes through a history and a chronology of all the reviews, etc. And then we come to what his claim was. Now, his claim, heavily relying on a report from a clinical psychologist, said that he'd been diagnosed with ADHD and complex PTSD based on his history and so on. And aspects of solitary confinement were likely to be particularly difficult for a person with ADHD. And then it goes through various grounds that he was challenging the decision of being kept in isolation. Very broadly, you can read this. As I say, I'm not going to go into great detail. I'm just going to essentially skim over it to give you what the broad grounds were and what the judge said about them. Ground 1, he argued that it was a breach of his right under Article 3 not to suffer inhumane and degrading treatment. Ground 2 was Article 8, right of ECHR, which was respect for private and family life. And in that respect, he was talking about telephone calls, restrictions and visits from friends being cancelled and all of those kind of things. Ground 3, saying that he was being treated less favourably because of his political opinions. Ground 4, he said that in a letter, he said, whilst the continued segregation will be under review, no change is currently envisaged. So in essence, his argument was, well, they're just not going to change their mind. That was under ground 4, which they said was unfair. So all of these grounds, you see, if something is unfair or wrong as a matter of law, those are all grounds for judicial review. So either wrong as a matter of law, or it's unfair, what we sometimes call as Wednesbury unreasonable, so it's so unreasonable that a reasonable person wouldn't have made the decision, and so on. And ground 5, although that fell away, said that he was denied the opportunity to make meaningful representations, and so before decisions were taken. But that ground was abandoned, and so the judge said no more about that. The judge then goes through discussions, a general discussion first, permission to rely on the reports, and so on. And then the judge discusses these grounds. Now, there was a lot of agreements between, and here's a really key point as well. There were a lot of agreements between counsel for each side because obviously, one being in prison, it was obviously agreed that no one should be subject to torture and inhumane and degrading treatments, but there had to be a minimum threshold for this to be crossed. But also, they agreed that by being in prison and by being segregated from other people, i.e. being kept in isolation, did not automatically or impose an absolute prohibition on the segregation by virtue of Article 3. So, in other words, it is not automatically inhumane treatment or punishment or degrading treatment under Article 3 just to be kept in isolation. And both sides had to agree with that because it's something that they can make the decision on, they can review, and ultimately that's what they did. And again, Mr. Williamson here was Tommy Robertson's counsel, agreed that there was nothing to suggest that this decision to segregate him was taken for the purpose of breaking his resistance or humiliating or debasing him. So in other words, the judge here says, and his own counsel accepts that this decision was not taken for breaking him or humiliating him, debasing him, etc. The judge says, on the contrary, all the evidence shows that it was taken for his own protection, the interest of preserving his safety from him, from other prisoners, and indeed even staff. And that it was not just mere speculation that he would be at risk, it was a very real risk. He knew himself that there would be that risk, and so this had to be reviewed and considered. So again, the judge went through there were several aspects, that he had several hours a day out of his cell, which was more than twice allowed for other convicted prisoners held in isolation. His mental health was regularly reviewed, etc., etc. And the judge ultimately said, in light of all this, it's been reviewed, it's been taken as a serious decision for his own safety, etc. Ground one, as in the inhumane and punishment and torture ground, was not arguable. So that ground fell away. So the judge will go through systematically each of the grounds argued and ultimately decide if they are arguable, then there will be permission to appeal, even on one ground or part of one ground, not necessarily all of it, but part of it. But on this first ground, it was not arguable, so permission would be refused on that ground. And then the judge systematically goes through the rest. And an interesting trivia on aside, I've been at permission hearings before, again, similarly, where you get grounds to appeal. And so very often, if you've not drafted the grounds yourself, you are tied to the grounds that have been submitted, which can be quite frustrating and limiting in what you can argue. And so sometimes you try to weave around those a little bit, and sometimes you get judicial praise for trying to put as much in as you can, but ultimately they very often fail. So ground two. Remember, this is the Article 8, the right to private family life, etc. Very short argument here. Judge said 2 hours of visits 4 times a week was substantially more than other prisoners were entitled to. He's also able to speak to family and friends on the phone for up to 4 hours a day. Cancellation of visits and curtailment of calls with associates believed to run social media platforms is a proper response to the need to avoid the use of his incarceration for campaigning purposes, and therefore this ground was not arguable. And that warrants a little bit of explanation, because I've had more than a few people ask me about this as well and said, why are his visits being stopped? Well, quite simply, those visits were stopped because it was believed, and in some instances I think was being used to broadcast the views being expressed during those visits. And so the prison can and did limit and stop those visits. For example, if I were to contact the prison and say that I wanted to come and chat with Tommy Robinson, I've had him on my channel before, as you know. The prison would obviously ask, what do I plan to do with the material or whatever, and may require me to sign an NDA, which they're allowed to do. And if they deemed most likely that I'm going to broadcast here to you whatever the conversation I've had with him, they could just refuse my visit as well, and they're perfectly entitled to do that. You may not think that's fair, but it's prison after all. They do, in essence, they do get to decide the rules. So they probably would refuse that visit if I applied. Ground 3, moving on, this was the one about his political views and whether he was being segregated because of his views. Now, Judge quite rightly said here that this decision was taken because of risks to himself and others. The judge said that the fact that these risks arose because of his well-known political views does not mean that he's been adversely treated because of those views. So even if his views were the reverse, and the judge said, in other words, what drove the segregation decisions were the risks, not the ideology. So whatever his views, whatever the ideology, just for example, completely separately, Rudy Cabana will be treated because of the risks to him and the risks to others, as against obviously what he's done and whatever his views are. And so the judge said here that those decisions were taken based on the risks, not based on the views. And accordingly, the judge said, that being so, this is not a case where you can point to any direct discrimination at all. The complaint is not put as one of indirect discrimination. If it were, it'd be necessary to show that espousing his views would be likely to be accommodated in segregated conditions. And so ultimately, this ground was not arguable either. Ground 4, and this was the final ground, this was based on the letter, and the argument in essence was, well, they've written this letter to say, well, we might consider it, but it's not likely. Therefore, in essence, saying that they've made their mind up already. They're not really going to think about it. They're going to pretend to think about it, but they're not really going to think about it, and they're not really going to change their mind. And in essence, that was the argument. The judge said here, this ground was based on a quotation of the governor's letter from December 2024. However, even the part of that letter which the judge has quoted made clear that his segregation would remain under review. The subsequent documentation disclosed shows that it did remain under review, and the intervals prescribed by the prison rules are and applicable policy. There is nothing to justify, the judge said, the suggestion that the governor has confirmed that this position, i.e. his segregation, will not change. In fact, at each stage, she has affirmed that the situation would remain under review, and in any event, this claim isn't brought against the governor, but against the Secretary of State, whose obviously the permission is required for the continued segregation every 42 days. So you may find difficulty with that argument. In essence, what the judge is saying here is that it's not the governor's decision, because remember from earlier in the video, segregation beyond 42 days and every subsequent 42 days, remember, requires the permission of the Secretary of State. So the judge, in essence, is saying here, it's not the governor's decision, regardless of what the letter said, because permission has to come from the Secretary of State. You may find that unfair, because you may think to yourself, well, the governor does have a say in this. The governor is, in essence, asking for permission from the Secretary of State. So it does sort of rest on the governor in that, let's say, for example, I'm not saying this is the case, but let's say if the governor had decided unfairly, which is not what the judge found, to be clear, but if the governor had decided unfairly that I don't care, I'm going to segregate him regardless, I'm not going to consider any change, I'm just going to go, pretend to go through the motions and leave him there segregated, it still requires the permission from the Secretary of State. So there is a safeguard there. So even if, which is not what the judge found, but even if the governor was being unfair, it still requires the permission from the Secretary of State. So there is that safeguard there in place. And then the judge went on, there is nothing at all to suggest that the Secretary of State has fettered her discretion as to whether to grant that leave. In other words, there is nothing to suggest that the Secretary of State has also resigned herself to that decision without considering it either. And accordingly, the judge said this ground is not arguable either. So overall, it was not found to be degrading treatment. It was not found to be a breach of his family right because he's had access to phone calls and so on. It's not because of his views. It was because of the risk. And finally, it was not just that they've decided already that he's staying in isolation regardless and they're not considering it. Judge said there was nothing to suggest that that was the case. Now, you may be cynical and think that, well, if that was the case, there's not going to be any evidence that that's the case. And that is an inherent problem with things like this, because let's say this is not what the judge found, and I'm not saying that it is, but if the governor and the Secretary of State had both decided to be unfair, it's virtually impossible that there would be any evidence of that anyway. And the judge is not going to find that that is the case without evidence that that is the case. So you may remain cynical. That's your prerogative. You may remain of the view that the governor's being unfair and the Secretary of State's being unfair and that they are just keeping him there regardless and they're not fairly reviewing it, etc. That might be what you think. That's not what the judge found. And as I say, it'd be impossible to find evidence that that's the case unless, For example, in the absolute wildest situation that there was some WhatsApp message that floated out from the Secretary of State in some private group or something that just said, yeah, I'm going to keep him there regardless, let's punish him, something along those lines. That would be evidence that they are deciding to do that regardless of any decision and review, etc. Obviously, that's not the case. The judge said there is no evidence to suggest that that is the case. Nothing at all to suggest that Secretary of State's fair to the discretion as to whether to grant that leave. So, as I say, no evidence that that's happened. So therefore, ground 4 is not arguable. And for those reasons, permission to apply for judicial review is refused. And it's entirely possible that they expected that decision because this was, as I said earlier, not a rolled up hearing. And so that's what happened on Thursday. So it does answer a lot of the questions as to whether or not he's been kept in isolation, whether it's his choice, whether he objects to it, whether he's got access to phone calls, all those kind of things. A lot of those questions are now answered because before, a lot of it was just speculation or bits of reporting here and there. And so you can, I think, understand why the prison is limiting the reporting from people visiting Tommy Robinson in prison. Now, a lot of people think that he should be able to do that, but at the end of the day, he's in prison. And so they want to limit someone in prison essentially shouting from the rooftops about how unfair it is in prison. So that's what they're doing. You are entitled to feel that that's unfair, and I perfectly understand that. The system allows them to prevent that, and this claim that is being unfairly treated has failed. So let me know your thoughts and comments in the box below. He will be out, just as a reminder of the dates here. He is due to be automatically released at the halfway point on the 26th of July 2025. But obviously he's also facing the other offences and so on. Let me know what you think in the comments. Please do subscribe to the channel to get updates on this. And as always, thank you for watching.